Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have our founding attorney, Louis Landerholm, with us to talk about why divorce cases seem to take so long and factors that can impact the timetable of a dissolution. So, Louis, how are you doing today?
Oh, I'm doing great. How are you, Steve?
I'm doing well. I'm doing well. This is an interesting topic because, I talk to folks who are either going through a divorce, have gone through a divorce, just on various occasions, and when I say I'm working for a law firm that handles divorce cases, one of the first things I hear is, oh, I don't understand why my case took so long, or they're going in why it's taking so long. So let's start by talking about that a little bit. And I want to flip that question a little bit and ask instead why a divorce shouldn't be rushed through.
Yeah, and that's really what it comes down to. Divorce it's a complicated situation, right? We've got, just like a business, I analogize it to a business all the time, right? The parties are so intertwined in their business that when we have to unwind that and we have to put everybody back into their own, to their own pieces of assets, you don't want to do that quickly. There's too many financial ramifications if things are rushed. There's too many risk of not doing it the right way. If you look at a business where you have multiple partners and you've got all these competing interests to unwind, the same thing goes in a divorce. Plus, in a divorce, you have the emotions are running so high that a lot of times it's best for parties to take a measured approach so that you don't give up something that either you didn't want to or you didn't understand what legally was correct or incorrect. And so it's not only that that it takes a while for all of that, but the system is meant to be slow. Like, the system wants the divorcing process to be slow because we don't want parties to feel rushed into making decisions that will impact the rest of their lives.
Well, that makes sense. And it's one of those deals where it's really difficult and in some cases nearly impossible to make a change if you didn't get right the first time.
Especially in Oregon. So in Oregon, when we're talking about a divorce, you typically have, if you have kids, then you're talking about the kid issues, custody, parenting time, child support. And then you have spousal support on the financial side as well, and all of the assets. So in Oregon, it's really hard to change custody once a custody decision has been made after the fact. And it's near impossible to change the asset piece. The asset piece is non-modifiable after the fact. So if you take custody and you take property division, and property division is typically the one that is there's a lot at stake on that side as well. And if you can't change that, then what you don't know or what you do or don't do will have dramatic consequences after the fact. With the parenting plan and with child support and spousal support, child support and parenting plan can be changed much more easily, but the spousal support can be changed, but it is more complicated after the fact.
Yeah. And that kind of leads to, what all needs to get decided. Because this is I'm assuming that the divorce decree, maybe we can talk a little bit what that actually is. It can't be issued until pretty much everything is actually decided, either by a judge or by the people in the divorce. Isn't that right?
Yeah, so we call it a judgment, formally known as a decree, or also known as a decree. People use it interchangeably. The judgment itself is a binding document. It's just like any other judgment that would come out of a case. So what's included in that document, or what sometimes more importantly, what's not included in that document, those things are, they are enforceable by the court. So we want everything included and we don't want to leave stuff out, because what inevitably happens, the things that get left out then become a point of contention after the fact, and then you have to go through that process over again. So, the people feel like, that's another piece of why it takes so long. Even when you go to court, the parties and attorneys are like, oh, we went to court, this is done. Well, it's another 1 to 2 months typically to get the judgment actually done, and all of the clauses that are so important for post-divorce, litigation. So if you have those clauses in the document, then if for some reason you have to go back to the court, the judge is that's the first thing the judge is going to do, is look at that document to interpret what was intended at the time of the divorce. And so you don't want it to be ambiguous. You don't want it to, to leave out things that you intended. If you just say the house is awarded to one party, but don't have any mechanics on how that's going to happen, how the other party is going to get off mortgage, how the other party is going to get off title, that causes that's a good example of then where things are left out of the judgment that cause a lot of chaos after the fact. And then if you have to go back to court, then the judge has to determine how that's going to be awarded to the other party.
Yeah, and I think what people don't realize, and because it sometimes doesn't even make sense, is that the judge may make a decision, but the judge then will generally tell one of the attorneys to write it up. And you may have an uncontested or a settled case, but like you said, if you don't take time to actually get it in writing correctly, you can turn that into another unsettled case. It's just kind of those things you have to get done right.
Yeah, we end up back in court fairly often in what's called a form of judgment hearing, because what happens is the judges or parties will agree on the big terms, but inevitably in the judgment we end up so we know what the what is, we know what's supposed to happen. It's the how that typically causes problems at the judgment stage. It's like, yeah, we're going to do this, but what's the timeline? How are we going to do it? Who's supposed to do it? Who has to pay for it? All of those things, if they're not in the judgment, or if there's contention with if the parties don't agree on how to do those things, then we end up back in front of the judge to go through the document to make sure that everybody understands what their requirements are and how they're going to operate under the judgment. So the initial ruling is obviously very important, but judges don't have time to go through every single thing about how the parties are going to operate post divorce. So that's where us as attorneys, we're working with the other side to draft and to make sure that we all agree on what the mechanics are going to look like.
And that kind of leads to, again, the time frame. So I guess there's two kinds of cases, sort of. I mean, three, I guess. But one is what they call an uncontested divorce. So everyone seems to be, ready to go. And then when not everything is agreed to, and isn't that sort of where the court's built-in sort of timelines can also dictate how long it's going to take? Because can you kind of explain a little bit about how even a simple case, how much it can take, and then how the court process works in terms of setting things like a trial? Because I'm assuming if you don't agree on everything, it's going to eventually have to go to trial.
Yeah, the premise of an uncontested divorce is that everything is agreed upon. So when, and most of the time, there's things that people need to work out. It's not that, everybody's thought about everything, and that because, clients don't do this every day. That's why we get involved, because, over the last 13 years of starting the firm and growing it to where it is today, we've seen tens of thousands of divorces where, for our clients, this is typically the only time that they have any sort of experience with the family law, world. And so in an uncontested divorce, really, I tell people, even if you agreed on everything, you're still looking at 3 to 4 months before a judge, all of the documents documentation gets put together, a judgment's agreed upon, it gets entered with the court, and then we wait for the judge to sign the document. So it's not even a fast process there, because we've got pieces that we can't control as we move through the system. If anything goes awry, and if there's a piece that the parties can't agree on, well, then, you typically, somebody files a petition, there's 30 days to respond. So there's a month right there. Then it goes into the normal calendar, and you're talking about wanting, trying to get done in Oregon within 9 months. That doesn't always happen. Depending on the county, it can be easier to push that date out than others. But typically, even if you're in court in 6, 7, 8 months, then you still have your judgment phase. So 9 months to a year is perfectly normal and expected if we need a judge. And it can be much longer depending on the issues and depending on the counties. Right now, even if we want to reset a court date today, most counties, we won't get a date until February, March of next year. So there's just some constraints. There's a lot of constraints put on the system based on the number of divorces and the number of judges.
That kind of leads to settlement. I mean, it's like, if you can settle and avoid a trial, obviously you can save some time, but the process of settlement isn't just an easy thing, is it? And one of the things you talked about is they don't know what they don't know sometimes. And that's where, to me, the attorneys are so valuable, because until they get the information, how can they settle? How can you settle if you don't know what the property is? If you don't have the information you need to reasonably settle?
Yeah, what happens, and this is, I talk to clients all the time about this, is, if you are going through a divorce, the first thing you do is try to figure out information. You're going to go to family, you're going to go to friends, you're going to go to the internet, and you're going to try to figure out what's going to happen in your case, based on the issues, based on the kids, based on the assets, and you're going to try to gather information so that you can, figure out, well, how does this apply to me? The problem with that is that every place you're going has limited information. So family and friends know 1 or 2 people that have gone through the process. So they're trying to apply your facts to 1 or 2 from, as compared to 1 or 2 other people in the world that have gone through the system. Then you go to the internet, and the internet's the most difficult place to go to, because then you get bits and pieces of information, and you don't even know if it's your jurisdiction. You don't know if that the facts are applied to you. So that's really where an attorney's knowledge comes into play, because we've seen tens of thousands of divorces. What we can do, we're in front of the judges every day. We know how the judges, what they're thinking about. We don't know exactly what they're going to do, but we know a lot of what they're going to do. We know how judges are thinking, specific ones, what they will do with a specific set of facts. So then we take the client's set of facts, and we apply what goes on in the courts to their set of facts to help advise them on what's really going to happen. And we're projecting, and we're making, estimations, and we're, guessing on, but it's an educated guess, because we are in front of the people who are the decision makers all the time, every day. So that helps clients be able to make decisions in a settlement negotiation as to, okay, maybe I thought I should get more than 50% of all of the assets because of X, Y, and Z. Well, we tell them the settled law in Oregon is that you're going to get 50%. So if you're going to fight against that, 1, you have to have specific sets of facts, and 2, it's going to cost you a lot of money to go fight that in front of a judge, and you risk paying attorney fees for the other side's attorney if you're fighting a specific set of circumstances and facts that are typically not going to get a judge to allow you to win that point. So these are all the things that in a settlement we're helping clients understand, and we're helping clients make decisions so that you're not spending time, money, and energy in areas where it's frankly not worth it a lot of times.
You're actually helping reduce the time frame by giving them the information. And I think also people sometimes don't understand the gathering process. And that especially, can be if someone says, I want to do this, well, doing this could involve an appraisal or, some sort of an evaluation, and kind of, can you give us a feel for, that sort of time frame to get some of these pieces of information that may be absolutely necessary?
Yeah, just like when we show up in front of a judge, or if we want to go to a mediator to help settle a case, sometimes we can't settle a case between the other attorneys, and so we're going to hire a mediator to be able to help with that process. In order for anybody to make a decision, we have to know numbers. We have to know the facts. We have to understand where the money is and in what form, because not all money is created equal when it comes to a divorce. Some people don't want retirement accounts because you can't access it. Other people value cash. Other people value real estate. So all of these things are important. The information gathering process is called the discovery process. In Oregon, there's mandatory discovery, but as attorneys, we have additional discovery that we ask for based on the facts of a certain case. So if somebody owns a business, then we need different information than if it's houses and retirement accounts and bank accounts. And then there's other pieces. There's the pieces that are voluntary discovery where people give it to us, and then there's involuntary discovery where we have to go get it through depositions or through subpoenas or all of those. So depending on what we need to do, if everybody's on board and they give all the documentation right away, it can be a pretty 2-3 month process. If we have to go do depositions, if we have to file subpoenas, if we have to go get information, it can take 5-6 months. It just depends on how complicated a specific case can be. But nobody wants to make decisions on what numbers or on what how to settle a case until we know what all of the information is. Unless the parties have just clearly said, yeah, we don't care about all of that and we want to agree on this, we will advise them accordingly on what could be out there, but it's within their, they're adults and they have the ability to make that decision. That would fall in the uncontested. But when we're in the contested realm, we have to give that information to a judge to be able to get what we're asking for.
And that kind of leads to, and what you're talking about is a lot of interaction with our clients. But then there's that whole other factor that really can be beyond your control, which is the other side. We kind of a saying goes that it can only go so fast as the slowest person. And that slowest person, if it's on the other side, it's going to make it more difficult to have a case and extend it.
Yeah, the thing with divorce and family law in general, that's different than other types of law is that we have 4+ people involved. We have 2 clients involved, we have 2 attorneys involved, and then we have a decision maker involved at some point. And so there's a lot of moving parts, and it's hard to, it's not always perfect and easy to predict what the other side is going to do. It may be it may be something that flares up at a specific time during the case that, there's no way to predict that, that the other party is going to either care about or slow down and not want to deal with it because of the emotions that are involved. And so, there are a lot of factors that are outside of our control. I always say, out of the 5, there's 2 pieces that we control, which is client and our, and us as the attorney. We can control how we are doing things, but we don't get to control the other 3 pieces. Judges may get sick and have to reset something. Judges may have too full of a docket and have to bump it out 2 or 3 months. Like, we don't have control over that. So the things that we want to do to make sure that we are helping our clients get through the process as quickly as possible is to get all of our clients' information as quickly as possible. Get our goals, really written out so that we know exactly what we're working towards. If we're all on the same page of what we're trying to achieve at the end, it makes our job easier so that we can start to work towards that. When goals shift in the middle of litigation, that extends the time, because maybe then we have to go after something that we didn't have to go after at the beginning. And so we're trying to, we're trying to make sure that the representation is individual to our client, and not every case is the same. So we're not going to do things that don't make sense for a client. But then, if we have to shift goals, then that causes us to do other things that just make it more timely and more costly. So, the most that we can do to be on the same page and to work towards a common goal and have that communication, flow back and forth, the faster the process is going to go.
And that kind of, sometimes it's hard for the client to understand, or anyone to understand. And again, when it's an emotional situation, what's going on, because you're doing 5, 6, 7, 8, 9 different things at once on this case, and it doesn't involve necessarily the clients having to do something. And so there's periods where, again, when I talk to people, it's like, well, I don't understand what they were doing for those 4 months or whatever, because I wasn't involved in it. And that's just sort of an issue that I think attorneys fight through, because it's, they don't want to spend more money by having to communicate every day with the client. But those things have to get done.
Yeah, it's always a constant concern, which is 100% understandable. Clients want to know what's going on in their case, but at times there isn't much going on in the case, and so we try to, we give those updates. And we will update a client on where their case is. But there are times when literally we're just waiting, and we're waiting for the other side to give us what we need. And there's no deadline at that point that's forcing us to do something. So, what we don't want to do is, input ourselves into the system and into that process to make it more contentious or to make it more expensive by causing work to be done. So we're constantly trying to balance what that looks like, pushing when we need to push, but also understanding, where to back off a little bit and let the process sort of, write itself out without then, spending, clients' money where it can be, unnecessary at times.
Yeah. And that kind of then flows into what are some ways that it can actually be sped up? And are there things that a client or spouse could do to help that?
I think, the biggest thing to me is if you go into it the expectation that it's going to be slow and that it's going to take time, it actually will finish faster, because we're not then forcing the process to do things that then cause it to be more difficult and take longer. So the more contentious it is, there's a balance. We're not going to sit there and do nothing for months on end, but we also need to balance that need to go and push something when we have the court involved. So we've got deadlines. We're eventually going to get all of these things. And so, it's, having a good relationship with opposing counsel when we can, that helps the process move along. And so being congenial and being professional with the other side really makes a huge difference. Same with parties. Yes, it's emotional. And it's very difficult to work with somebody who you're going to be divorced from. But the more you can, work through some of the things, have conversations, try to get through it as adults so that, the least amount of carnage, the faster the process is going to go, because you can understand the other person's position on things and try to, there's going to be give and takes throughout the whole process. So, the more patient, somebody can be, the allowing the process to work, it ends up going more smoothly and faster, and the more likely that settlement's going to happen, whether we need to get the help of a mediator, or if we can settle that between the parties with just the attorneys.
Yeah, and I think that emotional thing is really, really hard for people. But like you said, it's kind of understanding it. And I like when you said about setting expectations and having an expectation that, okay, there's a reason it's going to take a while, and I'm going to be able to understand that is a huge deal. Because it's otherwise, it can create tensions between an attorney and their own client if they don't do that or don't understand it.
Yeah, 100%, all the time. So, and we try to set that expectation, and again, our crystal ball isn't perfect by any means, but we try to give the reasons why something would take longer, or go a little bit slow, or go a little faster. So, that's constant dialogue throughout the process, and trying to advise our clients on what course of action to take.
Yeah, and just, I know we're almost got to go. We're almost already at 30 minutes. Wow, this goes fast. I think that the last 3 years, in COVID has slowed the process down, just because the courts were even closed for a long time, and has, in some sense, it feels to me, given a sense of like desperation that it's so long, and like that's that's always the way it's going to be, and I think coming out of COVID and getting courts back up and running will probably bring it back to where it more likely was a few years ago, and maybe even less, because now there's a lot of remote stuff that can get done that you used to have to wait for a physical hearing on.
We will see, depending on the county, cases, still take longer than they used to, probably for another year. But what we've done is really push, settlement options. So getting mediators involved sooner rather than later, judicial settlement conferences, getting into that process, and that's where the discovery process getting done sooner rather than later is important, because then we can engage in that dialogue and we can start that process. So, it's getting creative and doing things that, to not involve the courts as much as possible. Plus, then you have control over what that looks like, more than when you have to give it to the judge. And the technology has definitely come a long ways and will help to speed up the process.
Yep, absolutely. Well, shoot, we have hit our 30 minutes. And again, thank you, Louis, for explaining, this whole divorce timetable and process, and, why it can take a while for divorce, and even why sometimes it needs to take a while. So thank you so much for being here today.
Yeah, you're welcome anytime.
Oh, absolutely. And everyone else, thank you for joining us today. If anyone has any further questions on today's topic, you can post it here. We can get you connected with an attorney here at Pacific Cascade Legal. And until next time, stay safe, stay happy, and be well.